A Florida woman and her boyfriend are accused of brutalizing her nearly 2-year-old daughter. And after this girl was taken off life support, the couple now faces upgraded charges. And we're going to warn you, the details in this story are absolutely vile. But it is important to talk about what happened, what might have been done to stop it, and the punishment the suspects could face if they're convicted. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Little Zamora Lefo was just a couple months away from her second birthday on September 10th when she apparently endured unimaginable abuse. And it is that alleged abuse that led her to being rushed to a children's hospital in critical condition, and she would never go home again. According to Action News Jax in Jacksonville, Florida, more than a week after being admitted to the emergency room, Zamora's family made the decision to donate her organs and take her off life support. An arrest report for Zamora's mother reads, while at the hospital, doctors diagnosed the child as having a brain bleed, a broken left arm, fractures to both legs, vaginal and anal trauma, ligature marks around the neck, and bruising and scratching over the entire body. A toxicology screening revealed the presence of THC, methamphetamine, and amphetamine in the child. 20-year-old Zayla Goodwin and her boyfriend, 23-year-old Nathaniel Davis, were arrested one day after Zamora went to the hospital. Both were charged with child neglect. They were locked up on $500,000 bond each, but the story doesn't end there. Why? Because I mentioned, sadly, on September 18th, Zamora was taken off of life support. Now, first of all, before I go any further, there is, I suppose, a little ray of some light here, because her biological father, Brandon Foe, told Action News Jax that since her death, a 6-month-old girl received Zamora's heart and a 6-month-old boy got her liver. So in her death, she is helping others live. I want to talk about what Zamora apparently went through, though. So according to Jacksonville police, the medical examiner performed an autopsy and released their findings in December. And the ME found that this girl died of blunt force trauma and had meth in her system at the time of death. The coroner also found damage to the toddler's private area. And at that point, the case went to a grand jury, which upgraded the charges for both Goodwin and Davis, because Goodwin now faces one charge of aggravated manslaughter of a child. Davis faces 5 charges: murder in the first degree, aggravated child abuse, tampering with evidence in connection with a capital felony, and 2 counts of sexual battery. Now, neither had made bond on the previous child neglect charges, but that doesn't matter now because they've been denied bond because of the new charges. Not surprising there. So we were able to find a profile for Goodwin on TruthFinder, the powerful background checker. We just put in her name and state, Florida, located the profile in just a few seconds, and under her criminal history, we found her charges for allegedly contributing to Zamora's death. Now, Law&Crime, we partner with TruthFinder. We use it to get details on people involved in our stories. But even if you don't work in true crime, this can be an excellent resource to give you some peace of mind. After all, it's one of the largest public record search services in the United States. And with a paid subscription service, you can get access to unlimited reports about almost anyone. So right now, you can get 50% off of your first month of confidential background reports. You just got to go to truthfinder.com/LC-Sidebar. Now, we're not going to get into everything, but to talk some of the specifics of this case, I do want to bring in Florida criminal defense attorney Kathleen Bogenschutz. Kathleen, thanks so much for taking the time. I know this is a horrific case to talk about. This couple was arrested September 11th. Zamora died a week later. The ME's report was released in December, and then it finally goes to the grand jury, our understanding, in March. And now we're at where we're at. It seems that timeline's interesting. It took a very long time to wait when the injuries to the child seem so egregious, but is that common?
For an ME report to take that long, yes. And frankly, when there's toxicology involved, yes, as well. So a lot of times, and I believe in the Jacksonville jurisdiction, which is Duval County, toxicology will go to the medical examiner's office, whether it's from a live person or a deceased person. And of course, we're talking about what was in the child's system at the time she died. So that would have gone through toxicology. So we wouldn't have had a full or a complete autopsy report until that was completed. I'm also wondering, we don't really have any information about whether they did, and forgive me for this, a posthumous rape kit on the child and were able to take some forensic evidence from her body. Um, and it's possible that the DNA testing, even whether there was DNA or not, doing the testing on the swabs that they were able to take from her is also something that held us up.
The sexual battery, though, tells us something, doesn't it? The sexual battery charges.
Yeah, my first thought when I looked at this case is somebody who's done criminal law in Florida for 16 years now, something like that. This is one of the worst cases I've ever seen, and I don't say that lightly. Um, there are several different ways that the state can get to going for a death sentence in this case. Recently, the Florida legislature passed a law allowing us, Florida, to try for a death sentence on just a capital sexual battery case where the child lives. And in this case, it will be an aggravating factor that the state would use in order to go for capital punishment. And unless there is some information that we're not aware of in this case, I would expect to see the Duval office try to go for that.
Why do you have one charged with murder and the other one charged with manslaughter?
Well, so aggravated manslaughter of a child is an interesting charge in Florida. Um, Intellectually interesting, I'm sure. Nobody other than lawyers says it that way. But one of the ways that you get to aggravated manslaughter of a child is committing aggravated child abuse, and maybe you don't intend for the child to die. We heard things about ligature marks. One of the ways you can get to aggravated child abuse is by caging, and I know it's horrific, caging or restraining a child. It would certainly seem like those ligature marks would meet that. Not getting the child medical care when needed. I expect the medical examiner's report is going to have x-rays of the broken bones, and we'll be able to see if there was any healing as to how close to the time of death the broken bones occurred. And the other thing is, I think it was one of the femurs that was broken too, which is the strongest bone in the body. So that kind of underscores the kind of force that would have had to be applied to this small child. So, and it's also possible that they're looking at timelines as to who was with the child at the time that the injuries were allegedly inflicted. Mm-hmm. So a lot of times in like shaken baby cases, the child's not old enough to tell us what happened. And there's the nature of the offense is that you don't do it in front of other people if you're inclined to commit this kind of offense. So you're trying to put together a timeline, and doctors can tell you it happened between 6 and 10 hours ago. Well, if there was only one adult with the child in that 6 to 10 hours that would have inflicted the fatal injuries, then that would explain to me why perhaps the mother was only charged with aggravated manslaughter by leaving the child with somebody she knew was actively abusing the child, and the abuser was charged with murder one.
Let's get into some of the details here of what police say they found inside the home where Zamora was staying and what witnesses had to say in interviews. So one of the people that detectives interviewed was Goodwin's grandmother. This is Zamora's great-grandmother, Madeline Pass. And she apparently told police that Goodwin, Davis, and Zamora had moved in with her and her boyfriend in their Jacksonville home. The three had previously lived in Hillard, which is about 45 minutes northwest of Jacksonville. And why they had decided to move in with Goodwin's grandmother, not entirely clear, but they'd only been there a few days when the shocking alleged abuse was uncovered. Now, emergency responders, they first went to the home after a call about an unresponsive child who had possibly suffered some sort of cardiac event or arrest. And Zamora was rushed to a children's hospital while police got a search warrant for an intensive search of that home. And according to Goodwin's arrest report, Zamora was in such bad shape that officers went ahead and called in the homicide unit. Officers reportedly found multiple cell phones as well as marijuana, a pipe believed to be used to smoke methamphetamine. The report also stated, quote, detectives located multiple bandages with blood blankets near the child's bed, and blood diapers in the trash. And when police interviewed Miss Pash, she told them that she started seeing bruising on Zamora's body right around the time Goodwin and Davis moved in. The report reads, When she asked Goodwin what happened, Goodwin advised Pass that while they were still residing in Hillard, Florida, the child fell in the bathtub, which caused her injuries. Pass advised she noticed the child was not walking anymore, but Goodwin kept advising the injuries occurred in the bathtub. Kathleen, what do you make of two other adults being in the home with Goodwin Davis, the 22-month-old, even if it was only for a short period of time? I'm sure they play an important role in all this.
I expect that one of the things that we're going to be looking at when eventually this goes into court is going to be the age of some of the bruising on the child, the age, as I said previously, of the fractures on the child. Bruising can also be, we all know this from just kind of living, that we know what an older bruise looks like and what a fresher bruise looks like. And somebody who's a doctor can look at bruising and tell you, I can put these kinds of parameters as to when it occurred. So if there was one fall in the bathtub, you'd expect all of those bruises to be of a similar age. And toddlers are clumsy. I have a 16-month-old who's got bruises, all over her from running into things and tripping and all sorts of stuff. But, they're minor. And to cause the traumatic injuries in this case, I cannot imagine a scenario where a child could fall in a bathtub and break their own leg, or both of their legs, or cause such a traumatic head injury that it ends up being a cause of death. Because when you think about toddlers, they're only a couple feet off the ground. And if this is what I used to tell juries when I did child abuse cases, if we as humans were, if we were mortally wounded by doing things like falling off a bed or slipping in the tub as toddlers, we as a species would be extinct. We all know toddlers are clumsy little things. They run into things. They have a meltdown and then they're okay. And very rarely is it a very severe injury. So to be able to create these kinds of injuries I would expect to see the medical examiner testifying that these are the kinds of injuries you would see from her falling off like a 3-story building or something like that. That's the kind of force that you would need to break these bones.
When you hear about all the drug paraphernalia that was allegedly found inside this home, not the first case that I've heard of suspected child abuse or convicted child abuse where the perpetrators are drug abusers, but when you think about that, could drug abuse, addiction, what factor does that play either in the prosecution or defense of this case?
So one of the things that a jury is going to hear is that voluntary intoxication is not going to be a defense for the person or people who are inflicting these injuries on the child. And by voluntary intoxication, I mean that the person took the drugs voluntarily, as opposed to somebody drugged them. This is certainly, we're talking about paraphernalia. We're assuming that the person who was doing these drugs knew what they were doing. And a lot of times methamphetamine can make you paranoid. You never know what it's cut with. It certainly could have contributed to this scenario, but it's not an excuse. My question would be more of the fact that it's in the child system. Were they smoking it around the child? And that by itself is probably enough to get to child neglect.
Well, here's what Goodwin apparently had to say during her own interview with detectives after being read her Miranda rights and signing a constitutional rights form. This is according to the booking report. Quote, Goodwin stated the child fell in the bathtub about 1 week ago when her boyfriend Davis was giving her a bath. She didn't see the child fall, but he told her the child fell backwards, stood up, then fell forwards. After the child fell in the bathtub, she had difficulties walking. Prior to this incident, she did not notice any bruising or injuries outside of a normal toddler's bruising to the child's body. Goodwin also advised the child's lips became really red and swollen 1 day ago, but she believed it was an allergic reaction. She gave the child medicine for the swelling, but it appeared to not work. The child struggled with eating and drinking due to her mouth hurting and swelling. Goodwin stated that she scheduled an appointment with Zamora's primary care physician for Friday, September 13th, but otherwise did not seek medical attention at the insistence of Davis. Now, Only some of the dates that were provided within the report are exact, but Zamora was rushed to the hospital on Tuesday, September 10th, and Goodwin told police that the girl had fallen in the bathtub around a week ago. So if we assume that that happened exactly 1 week earlier, that means Goodwin wasn't planning to take Zamora to see a doctor until 10 days after she fell. Kathleen, that's the problem, right?
Yeah, and I'll tell you, at one point in time, my kid, she had sunscreen on, took her in the bath, was bathing her, so sunscreen plus soap, and she slipped out of my hands and knocked herself in the head, and I was at urgent care in seconds, sobbing. And I think that most parents who are sitting on a jury who hear something like that um, are going to be incredibly judgmental of that. Uh, it is. It also kind of defies belief that there was this injury that was kind of like simmering below the surface that just kind of exploded a week later. That's not the way these things work. There's also going to be some evidence of things like retinal hemorrhaging in a child with a serious head injury. And we'll probably hear testimony that a fall could not, as I said previously, generate the kind of force um, that would create those kinds of injuries. Children's brains are smaller than their skulls. That's why it's so dangerous to shake a baby, because their brains can rattle around in their skull. And what you'll see in their eyes is something called retinal hemorrhaging. And that is from the brain slamming back and forth in the skull and little blood vessels in the eyes breaking. Um, a child who falls from, 22-month-old is what, maybe 2 feet tall, 2.5 feet tall. A child who falls from that height, even into a tub, you cannot create that force. So while this is just a horrific case, those of us who are, a little bit interested in the science of these things, I expect we're going to hear some really interesting expert testimony about how that is impossible. Not saying she didn't fall down in the bathtub a week before, but that's not what caused these injuries.
So here's a question. What happened on the 10th, right? Well, according to police, this police report, let's talk about it. Quote, during the early morning hours of September 10th, Goodwin advised she was wakened to Davis yelling. When she got out of bed, she observed Davis yelling and performing CPR on the child in the hallway outside their bedroom. When she asked Davis what happened, he told her he found her unresponsive, unconscious, face down on the mattress next to their bed. He tried to wake her up by putting her into the bathtub, but she would not wake up. He then attempted CPR while she called 911. And remember, when Zamora got to the hospital, her little body was riddled with injuries, broken legs, ligature marks around her neck, a brain bleed. This child hadn't simply fallen asleep and not woken up. Now, the booking report also noted that Goodwin told officers she never saw the bloody diapers or bandages in the home, despite crime scene investigators finding them during that search. And the police report provided some more insight from a child abuse injury specialist. The report reads, Dr. Barbara Knox, MD of the First Coast Child Protection Team, advised any reasonable caretaker should have known to seek medical attention for a child in this condition. Dr. Knox described the injuries as less than 10 days old in age, as there were no callus formations on the bone. Dr. Knox stated that the fractures to Zamora's legs would have caused intense pain, and any reasonable caretaker would have sought medical attention. According to the timeline given by Pass and Goodwin, Zamora would have been injured at least 3 days prior to September 10th. According to Pass, she didn't observe Zamora walking after they moved to the residence in Duval County. So Kathleen, we get back to that issue of timeline and also that idea of different narratives of what happened. And I am, of course, curious if you're going to have two defendants pointing the finger at one another.
Well, in this case, that is potentially going to be their best defense in this scenario, or maybe a three-way pointing where unfortunately the great-grandmother is involved because she was in the house, if that meets up with the timeline. When there is a victim who cannot express themselves, whether because they're deceased or because they're young, or in this case, both, the timeline is the most important thing. So exclusive access to the child, I get the feeling that the way that this was charged in the first-degree murder is allowing the state to go for all of the lesser included offenses, just in case this ends up being the defense as to the two of them. But I would venture to guess that they're fairly confident in their timeline. If they indicted for murder one, they indicted for the capital sexual battery, and they've only left the mother with the aggravated manslaughter of a child.
Now, let me give everybody a statement from law enforcement. Hear what they had to say about all this, right? The statement reads, the Jacksonville Sheriff's Office will work with the state attorney's office to get the harshest punishment possible for this heinous crime against an innocent child. Children are our community's most precious asset. Now, murder is a capital crime in Florida, meaning, as we've been talking about, prosecutors could potentially seek the death penalty against Davis. That could be an incentive maybe for him to take some sort of deal, right, Kathleen? I mean, do you think that that option would even be on the table for a man who's accused of murdering an innocent young child like this?
It's entirely possible. I'm not in the decision-making chair for that office. It's possible that they offer him a life sentence to testify against mom. I think that as a mother myself, there's a special place in hell for someone who leaves their child with someone they know or suspect is doing something like that to them. And it's possible that maybe the case against the mother isn't as cut and dried, so they make a deal with the devil.
But if they think he's the one who murdered her, that's the tricky part. Because look, she's facing that aggravated murder, manslaughter charge, first-degree felony, life in prison. They're both scheduled to appear in court for arraignment on April 2nd in Jacksonville. But it seems that he is being, at least from the charges, the one who's more culpable now.
And it would seem that the state attorney's office is pretty confident in the fact that he is more culpable because they've gone forward with this indictment, meaning they presented it to a grand jury and had them indict on him. And let's also remember that, number one, we've got a capital homicide, right? We've got the murder of a child. We've got 2 counts of capital sexual battery, which is now punishable by death in Florida, although it has not, it's entirely possible and in fact probable that there's going to be a constitutional challenge there. So there's multiple ways that you can get to the kind of aggravators that would support a possible death sentence, or at least trying for a death sentence for the state. So, and there's also the hack aggravator, heinous, atrocious, and cruel. And if this isn't it, I don't know what is. Yeah.
Yeah, no, I don't know what is either. This is a really distressing case, really, really upsetting one, but important one to cover nonetheless. Kathleen, thanks so much for taking the time. I know this is not easy to talk about, but appreciate your perspective and your expertise in this area.
Thanks.
All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.